7:35 here on this Friday morning. Jimmy Barrett, News Radio 1140 WRVA. A couple of court rulings by the U.S. Supreme Court on Texas lawsuits. One of them involving affirmative action, the other one involving immigration. Of course, that was the big one that came out yesterday. Here to talk about with us is Byron Henry, a Texas-based constitutional attorney. We ended up with a 4-4 split with the justices on this one, Byron, so the lower court ruling holds, and the president's executive order is therefore rescinded. And for all practical purposes, what do you think the Supreme Court was looking at here as far as their determination that what the president did was not constitutional?
Well, probably, even though the Supreme Court didn't actually issue an opinion that what President Obama did was outside his authority or unconstitutional, probably the idea that he changed the status of these individuals from unlawful to lawful so that they could get driver's licenses and other government benefits and be able to work in the United States. That's probably what tipped the balance. The prioritizing of deportations is something that the executive has done, both Republican and Democrat, for years, and in this case, I think it was simply the extra step of changing their status in contravention of current federal immigration law that probably tipped the balance in favor of the court leaving this ban or this prohibition in place and keeping that executive action from going into effect.
From a practical standpoint, life doesn't change much for these illegals, does it? They're still in this country. There's not going to be an effort on this administration now all of a sudden to deport these people. It just means they're not going to be able to get the tools necessary in order to be able to work.
That's correct. Driver's licenses, work permits, and a few other benefits at the state and federal level they would have been entitled to are not going to be available to them under this action at this time. And of course, this will probably effectively kill this program because it will not be resolved before President Obama leaves office.
Right, and unless, of course, the next president happens to be Hillary Clinton and a new Supreme Court justice that is seated that is more liberal, in which case we could end up dealing with this all over again, right?
Yes, certainly, and that's one thing I've noticed is that the Obama administration probably caught a break with the passing of Justice Scalia because he probably would have added a fifth justice to actually issue an opinion which effectively would have declared this action unconstitutional, which would have prohibited the next president from taking any action. Because there was no opinion on the issue from the Supreme Court, the next executive is free to take whatever, give it a shot again and take another chance on an executive action on immigration.
We're talking to Byron Henry. He's a Texas-based constitutional attorney here on News Radio 1140 WRVA. Let's talk a little bit about that affirmative action case. As I recall, it was a young white college student who didn't get in. Was it medical school?
No, it was undergraduate school at the University of Texas, and she's long since graduated both from college and graduate school now because the case is so old. But her argument was basically that the limited number of open slots that University of Texas has to admit freshmen with discretion, she was basically locked out of that because of her race and because they rely on race too much as a factor in admitting their freshman class. And this case has been up to the Supreme Court twice. And what the Supreme Court said here, in a very narrow opinion, by the way, Justice Kennedy writing for a 4-3 court because Justice Kagan was also recused in the case, was basically that the University of Texas created a unique plan, different than other ones in the country, in which race was a minor factor among a lot of other factors in order to get some sort of educational diversity in the classroom and both the educational environment on campus. But it's certainly a win for the University of Texas, and affirmative action does live. But if you read the opinion, you'll understand that Justice Kennedy warned universities to keep race to the extent they need to use it at all. They're going to have to just, and it's only going to be a minor it needs to be a minor factor among lots of other factors if the universities are going to use it.
So in other words, Byron, in this particular case, if that had been the sole or the majority factor for her not to be admitted is because somebody else had to be admitted that was less qualified and only trumped her in the race card, then they probably would have had a problem with it.
Oh, they certainly would have had a problem. Justice Kennedy made clear in the first opinion in the Fisher case that a university has to build a record at the trial court as to both how much race plays a factor, and it needs to be a minor factor, but they also have to justify why they could not achieve the diversity they were looking for using other factors. And race basically is sort of a last resort factor that they can use if necessary and if necessary only. So certainly like I said, affirmative action is still allowed. Race is still allowed as a factor, but it's a yellow light to universities across the country. If they're going to use race, they need to proceed at their own peril.
All right, Byron, good to hear from you. Thank you. That is constitutional attorney Byron Henry joining us here on News Radio 1140 WRVA.